in mediation. My name is Santo Di Gangi, and I serve on the Florida Bar Young Lawyers Division Board of Governors, and I'm a civil litigator down in West Palm Beach, Florida. This webinar is being co-hosted by the Florida Bar Young Lawyers Division and Upchurch, Watson, White, and Max. So everyone attending today will receive one general CLE credit, and you will receive that code at the end of this presentation. For those of you who are not aware, the Young Lawyer Division puts on a free webinar once a month on a variety of topical issues for young lawyers, and you're able to receive at least one general CLE credit and sometimes a half credit of the always elusive ethical CLE credit. For a list of any archived webinars that we've done in the past, you can go to the YLD website at www.flayld.org. That's flayld.org, and you can click under CL/PWP and then click webinars for a list of all the archived webinars we've done in the past. Our speaker today is Michelle Jernigan, and we're happy and lucky to have her. Ms. Jernigan's been a member of the Florida Bar for over 34 years, was actually one of the first mediators to become Florida Supreme Court certified in 1988. Ms. Jernigan is a shareholder with the firm of Upchurch, Watson, White, and Max, and joined the firm 24 years ago. The firm specializes in all forms of dispute resolution, including mediation, arbitration, mini-trials, and special masterwork. Ms. Jernigan is a past president, director, and founder of the Florida Academy of Professional Mediators. She's also a past director and member of the American College of Civil Trial Mediators. As a mediator, she has mediated thousands of cases in the areas of commercial, personal injury, ERISA, consumer, HOA disputes, land use cases, estate, first-party insurance, family business, divorce, medical, and legal malpractice. And she's also arbitrated over 100 cases. She has trained hundreds of mediators in Florida and also trained executives from Eckerd Corporation and Orlando Regional Healthcare Systems to mediate their own employment disputes. She's also an author and has published articles on mediation, family business mediation, and ADR. And as a side note, Michelle's firm, Upchurch, Watson, White, and Max, is a year-long supporter and sponsor of the YLD, and they are actively involved in supporting young lawyers around the state, so we're very fortunate to be working in conjunction with them. I do want to note, as many of you know, the weather today all around the state of Florida and around the country is rather severe and rough. If for some reason we do lose power at some point, don't leave. We have many backups in place in order to resolve the situation. And without further ado, I am happy to welcome our guest, Michelle Jernigan.
Santo, thank you so much for that warm welcome. I really appreciate it. And I also want to thank our staff, and in particular Kathy Klosny, who really makes these things operate in a seamless manner, and I really appreciate that. And lastly, I would like to extend a special thanks to the Young Lawyers Division for giving our firm an opportunity to present with them as sponsors, not only in this seminar today, but also throughout the year in the various events that we're involved in. It's been such a pleasure to have the opportunity to work with the young lawyers, and I look forward to giving you this presentation this afternoon. I thought about this presentation a while back. In fact, I generated it in a desire to try to help people understand a little bit more about the negotiation process in the context of mediation. And so that's what we're going to be dealing with today, and I picked the topic negotiating around and through the minefields in mediation as our title today. I'm having a little bit of trouble moving the slide forward, so give me just a minute here. There we go. Next, okay. All right, well, you know, this is something nobody really ever wants to hear anything about, is preparation, but the reality is it is an essential part of being a good lawyer and being a good negotiator. And you should always prepare just as much for a negotiation or just as much for a mediation that you would for a trial. And I just thought it was interesting when I was able to locate Gerald Williams' book and his quote here. And actually what he's doing is he's quoting another lawyer, but obviously it says, in my experience, the most important part of negotiation is thorough preparation and a complete knowledge of the strengths and weaknesses of your position. And I can tell you, having observed it firsthand many, many times, that the lawyer who is the most prepared at mediation is definitely the most successful. Obviously, sometimes you are stuck with certain facts that don't favor you and certain legal principles that don't favor you, but I have literally walked out of mediations at conclusion and had a defense lawyer tell me, Michelle, I paid $50,000 more on this case because of who the plaintiff's lawyer was and because of how they were prepared. So it definitely makes a difference. So let's look at a couple aspects of preparation. You definitely have to know the facts of your case. You really should know them inside and out. You should be able to tell them like a story. You should understand the legal principles that apply to your position. And you really should be able to argue both sides of the case just like you did in law school, with the strengths and weaknesses of both sides. And then we in mediation school use these little acronyms that I like to acquaint you with today: your BATNA, your MELANTA, and your WATNA. So BATNA is your best alternative to a negotiated agreement. You need to know what that is. What is your best alternative? Well, if your case is being tried in court, it is a win at trial. Well, what is your most likely alternative to a negotiated agreement? That's probably your most likely verdict, again, if your case is tried in a court of law. And what about the WATNA? That is your worst alternative to a negotiated agreement. So obviously that would be your losing position in a court of law. You should evaluate all of these before even going to mediation. Another thing, which might seem a little counterintuitive, is know your advocate. Know the lawyer on the other side of the case. Know as much about them as you can. What's their litigation style? Are they a bulldog? So do they try to gain an advantage by bullying people? Wouldn't it be helpful to know that? Are they a catch dog on a pig? You can tell I'm a Floridian when you hear these little descriptions. Catch dog on a pig would be somebody who just never gives up, is continuously and constantly persuading you, and always, always on at your heels, always trying to gain an advantage from you. Is it an elephant? Is it someone who just comes and sits in the room and just stays there, and their presence, just their mere presence is intimidating? Is it a rat who plays dirty? Or is it a fox who's sly, where you can't really even tell what they're up to? You should also know your decision maker. I say that because think about this for a minute. When you're in a court of law, the judge is going to make the decision. It doesn't really matter who the corporate rep is on the other side of the case. It doesn't make that big a difference, but for, of course, the evidence and the testimony they present. But in a negotiated resolution, such as in the context of a mediation, the person on the other side that's making the decision, you need to understand that person, how they think, what they're like, how to appeal to them, how to persuade them. All these are very important things for purposes of trying to get the resolution that you want to achieve within your mediation. And you know what? You can Google people. If you know you have a corporate representative coming and they're a higher up in a publicly traded company, you can Google them. You can find out a lot about somebody on Google now. And sometimes you might need to go through a decision hierarchy in order to actually find the person who's your actual decision maker. So don't be afraid to try to work your way up the chain of command to do that. And we already talked about this a little bit, but know the strengths and weaknesses of your opponent's case. If you can argue their case, then you certainly know and understand it. And here's a little chart that I got out of a book that I've used quite a bit. I found it to be really helpful. You know, back in '83, there's some authors, Roger Fisher and William Ury, and they're at the Harvard Business School. And in fact, they're the heads of a program there called the Harvard Negotiation Project. So in '83, they published this book, which is well known to everybody in the mediation business, called Getting to Yes, Negotiated Agreement Without Giving In. Well, not long after that, in '95, Fisher teamed up with Danny Ertel, and they wrote a workbook to kind of supplement or go along with the principles in the book that had already been written, called Getting Ready to Negotiate. And so this is a page out of that book that will help you prepare your case for mediation. So let's explore just a little bit here. You need to know what your interests are, not your positions. There's a difference between legal positions and interests. Interests are wants, needs, concerns, hopes, fears. Go ahead and brainstorm those with your client. Be sure that you know what it is your client wants to achieve in any litigated context and in any mediated context. The other thing is think about what are some of the options available. Not every lawsuit is about money. Sometimes it's about business deals. Sometimes it's about an accommodation within the context of the ADA. Sometimes it's about trying to forge through some anger that's happened in the past and maybe an apology is needed. And so what you need to do is you need to sit down and brainstorm with your client and try to come up with some options that might be feasible ways to resolve your dispute and try to achieve the interests that you've identified. You also need to take a look at legitimacy. Oftentimes within the context of a lawsuit and a mediation, what is legitimate external standards are frequently set by legal precedent, but not necessarily. Sometimes in a business mediation, the businessmen really want to achieve a business resolution that makes economic sense. So that could be a bar or a standard to work towards. Sometimes, believe it or not, people actually want what is fair. Now, fair is a very vague and often ambiguous concept, and people have different ideas about what fair is. But if parties are in agreement on what is fair, then certainly that could be established as a standard for reaching a particular type of an agreement. I mediated a case one time with 4 women, all who had a claim to one deceased man's life insurance proceeds. That was a very interesting case. Everybody had different relationships with this deceased man. One was a wife, one was an ex-wife, one was an ex-girlfriend, one was the mother of one of the children of the deceased. And it was really interesting because if we had set a legal parameter for trying to reach a resolution in that case, I don't think we ever would have gotten there. But all of those women said that their desire was that the child of the deceased receive the proceeds. And so what we did is we negotiated a settlement that best achieved that particular standard that everybody agreed to. And then, of course, you've got to understand what the interests of the other side are. What is it they really want? What are their concerns? What are their hopes? What are their fears? Because remember, in a negotiated context, you have to appeal to their interests because you have to have their consent to reach an agreement. Now, this is just a slide to show you a little bit about your walk-away alternative, because you do need to know when you enter into mediation, where are you really going to draw the line? And you don't have to express that to the other side, and you don't have to express that to the mediator. But you need to know how far you're willing to go before you end up just impassing or walking away. And of course, your walk away alternative is, in a litigated context, it's always going to be a trial. And then of course, if you reach agreement, then you are committing yourself to some specific option that you have identified. Now I want to talk to you a little bit about some negotiation tactics. And tactics are things that you might use yourself if you want to, if you're a competitive negotiator, not as frequently used if you exercise collaborative negotiation, which is what mediators frequently advocate that you do. But if you are going to use collaborative negotiation, then you still may encounter some of these tactics. And so I want to give you a few tips on how to be aware of them and how to respond to them. So let's take one that's very frequent and that we actually see a lot in mediation, and that is extreme demands. And they may or may not be followed by small or slow concessions, but I'm just going to go ahead and deal now with the extreme demands. You've got three choices, and first of all, be sure that you don't let it rattle you. Be calm, have a plan, and stick to your plan. So your three options are: you can reason with your opponent and you can explain, hey, look, I don't really understand the rationale for that demand. Can you explain it to me? And try to persuade them that absent some rationale, their demand really doesn't make any sense, and maybe set forth for their benefit what you think would be an appropriate demand given their best case scenario. And I frequently will call that the highest credible demand. So that's one thing that you can do. A second thing you can do is you can meet their ridiculous demand with a ridiculous offer. It's not very productive, but it might make you feel good in the moment, and it might be something that you really have to do. Like I said, it probably won't move things forward with any speed, but it's certainly an option. The third thing you can do, which I often recommend to folks if the first thing I suggested doesn't work, is go ahead, ignore the demand, and negotiate in a way that you deem reasonable. So make a first proposal that you think is a good first proposal within the context of not only the litigation, but also the negotiation that you find yourself in. So escalating demands, this is a toughie. Have you ever had a situation where somebody made a demand outside of mediation prior to the mediation, and then their demand goes up when they get to the mediation? You've got to challenge an escalating demand. The question is, what has changed to justify you escalating your demand? Even so, though, like extreme demands, you don't want to let this stand in the way of you making an offer. To me, you have progress in a negotiation if you have movement. If you have no movement, you have no progress. So, and I think also it's important to remember that the first demand will often serve as an anchor, and we'll talk a little bit more about the psychology of anchors as we move through the presentation, but keep that in the back of your mind that that first demand does serve as an anchor. The other thing is lack of authority issues, and I know we had a question posed on that, but we do have in Florida a rule that governs the authority that you're required to have when you attend mediation, and that's Rule 1.720, Florida Rules of Civil Procedure, and it basically lays out the very specific criteria needed to comply with the rule. I'm going to come back to that in a few minutes because I want to go ahead and get through this, but that sets forth who's necessary. But you know what the reality is? We still deal with lack of authority issues in mediation, and when I discuss the rule a little bit later down the road, I'll talk a little bit about that. So then we also have take it or leave it offers, and the bottom line is offers are never non-negotiable. So always test take it or leave it offers if you're the recipient of them. If you're making a take it or leave it offer, be sure that you really mean it, because you will negotiate with that lawyer again. So don't provide a take it or leave it offer and then move again. If you really mean take it or leave it, then you really need to get up and end the negotiation at that point. Trying to make you flinch, that really is about their intent to throw you off your game, to throw you off your plan. And the best thing to do is to keep calm, try not to react emotionally to any kind of crazy offer, and focus on responding in accordance with your goals and your objectives. Now, personal insults is something that I just don't allow in mediation. It's completely counterproductive. It just gets everybody riled up, and it doesn't do anything to move the process forward or to assist people in achieving a resolution. So here's what I'm going to say to you. Don't allow yourself to get emotionally rattled. It will affect you emotionally. And don't hesitate to take a break. Don't hesitate to take a walk. And don't hesitate to call on your mediator to assist you in putting folks in private session when personal insults occur. I don't allow personal insults to occur in mediation, and if they continue, I separate the parties because it's just not appropriate and it's not productive. We know in the context of negotiation, you always have bluffing and puffing. That's just exaggeration. Those are skewed evaluations, and it's always with the intent to try to throw you off your game and to try to gain an advantage over you. Lying is viewed a little bit differently in my mind, and lying is a misstatement of fact, and it is certainly grievable under the rules of professional conduct. And when I talk about lying, what I mean is making a misstatement about actually the evidence. Now you can argue or talk about what you think the evidence will show and what a jury will do with the evidence, but for instance, you can't just lie about facts in the case. That is not ethical part of negotiation. And we all know that there are common lies in mediation, and some of them are, this is all we're willing to pay, certainly test that. We have full authority, certainly test that. What are some threats and warnings that you could encounter? Well, what about, we're going to file a proposal for settlement. We're going to move to add punitive damages. We're going to file a motion in limine. Don't let any of those create a problem for you, because those are things they could do anyway. They're just trying to rattle you, because if they can get you off base, they can gain an advantage in the negotiations. Same with belittling your proposals. When somebody belittles your proposals, just stand firm. As long as you have a solid rationale behind your proposal, there's no reason to waver. Just be confident. You've researched your case, you know your facts, you've decided to negotiate your case in a certain way, and as long as you have confidence, don't worry about what the other side says about your proposal. Calculated delay or arbitrary deadline, this happens all the time in mediation. You know, the most standard but arbitrary deadline is I've got a plane to catch. But that's a real deadline that you're working up against. But you know, the way I deal with that is we try to achieve as much as we can before somebody has to hop on a plane. But the fact that somebody has to hop on a plane doesn't end the negotiations. I'll continue to follow up either by phone or by email. I don't consider the mediation closed until we've explored every available option for settlement and we've realized we're just not going to get there. Another technique that's often used is good cop, bad cop. Tactic, actually, a tactic. And you know, it can happen with a junior associate and a partner. You can see it in play with a corporate representative and a lawyer. It can happen between two decision makers, and just recognize that that is a tactic that the other side is using, and quite frankly, it can work very well. So a very good way to combat this tactic is to go ahead and have your own good cop and bad cop. Decide who's going to be the good cop on your side, maybe your client, and who's going to be the bad cop, maybe you. Now I want to talk to you a little bit about emotions in mediation, because I hear from people, well, this is not an emotional case. And I'm thinking, gee, are there people involved? If so, those people have emotions, and if so, those emotions are going to be in play in mediation. So the reality is emotions always exist. It's just a matter of degree in every specific context, how big a role those emotions are going to play. So the bottom line is we have to deal with emotion. We can't just ignore it. It's a reality. A few years ago, I took a class on neuroawareness. It was actually called Neuroawareness for the ADR Practitioner. And I learned a little bit about the brain, and I learned a little bit about the physiology of emotion, what really happens in our bodies when we experience emotion, how that affects not only physically how we feel, but how we behave, as well as our cognition, how we think. So not to get too scientific, but to go over a couple of principles with you I think you'll find interesting is we have two parts of our brain functioning simultaneously, but they're independent. They're functioning independently. One is called the low road, the other is called the high road. The low road is our gut. That is where we basically experience things on two levels, either fear or reward. Fear or reward. And then we have the high road, which is the part of our brain that deals with the executive functioning. That's the part that's in play in the decision-making aspect. Although that low road, those emotions, they can certainly affect that high road, that cognitive decision-making. So in a mediation context, we want some fear and we want some reward, because fear is a highly motivating factor, but so is reward. I think it's important for you to understand too that a social fear, such as the fear of losing a friend, the fear of losing a lawsuit, social fears are just as powerful as physical fears. They're no less powerful than physical fears. So our bodies are reacting the same way, and it has the same impact on our cognition if we have fear in the context of a mediation as if, for instance, we saw a snake or we're walking across the street and saw a car coming towards us. So let's think about some of the fears that we might experience in mediation. Maybe parties would experience the fear of losing at trial. They could experience the fear of settling for too little. Lawyers or parties could experience the fear of making a mistake, the fear of being coerced. Let's think about some of the rewards that might balance out in mediation and that folks could experience. Closure. Have you ever seen the look on people's faces when they finally get a resolution to a long drawn out fight? Have you ever seen the relief in their faces when they sign that agreement? What about the reward of crafting your own resolution, actually reaching a settlement that is different from any judicial result that could ever be imposed by a court of law? That's actually a better result than anything that can be imposed by a court of law? What about the reward of avoiding a bad outcome? Or what about just the reward of avoiding uncertainty and striking a good deal? So the bottom line is you can't ignore emotions. So what do you do with them? One of the things that I became familiar with after reading another book, yes, by Roger Fisher, and this time Daniel Shapiro, they suggest in their book called Beyond Reason, you can meet core concerns. They suggest that basically the way that you can deal with people's emotions is you can address their core concerns. And in a few minutes, I'm going to talk about what they've identified as some of the core concerns that I think you can wrestle with and deal with in mediation and thereby satisfy some of the emotional issues that will occur not only with your clients, but with the clients on the other side of the fence. But before we do that, I want to emphasize why we care about emotion in mediation. And here's the bottom line. Emotions affect behavior, they affect cognition, and behavior and cognition affect negotiation, and they certainly affect decision making. So the reason we care about emotion in mediation or in negotiation is because it affects decision making and it affects how people behave in a negotiation and mediation context. So let's go ahead now and look at these 4 core concerns that were identified in Beyond Reason. Expressing appreciation, building affiliation, respecting autonomy, and acknowledging status. Let's take the first one, expressing appreciation. So emotions are triggered when someone is feeling unappreciated. What do you think those emotions are? Rage, irritation, anger, disgust, resentment. How would that make someone behave? Striking out. How do you negotiate with somebody who's striking out? What are some of the feelings that can be experienced when someone feels appreciated? They can feel valued, they can feel cared about, they can feel compassionate, and guess what? What's the behavior that's generated? They're more likely to cooperate. Now, it's important that you understand appreciation does not mean giving in. It does not mean that in any shape, form, or respect. But it is very helpful when you want to express appreciation to communicate your understanding. And some of the ways that you can do that is you can present open-ended questions. Hey, help me understand how you see things. Help me understand your position. Educate me about what cases you have to support your position. Of all the things we've talked about today, what's the most important to you? That's not only generating some compassion for the other side and some understanding for the other side, it's also delving into what their interests are, which is important for purposes of trying to figure out how to settle the case. What are some of the concerns that you might have about our proposal or about what we have suggested as a means to resolve this? What are some ways that we can work around that? Building affiliation. This is where I'm kind of going back to your adversary again. They talk about turning your adversary into a colleague. I know this is all very counterintuitive, but a big part of working together involves affiliation. And when we are affiliated with someone, working together is much easier. So how do we do this with somebody on the other side of the case? How do we turn them into our colleague? Well, some of the things that you might consider are meet with them informally, take them to lunch, tell them you just want to talk about the case, tell them you just want to get to know them a little better, use first names, refer to some of the things that are important to them with respect to either their personal interests, their professional interests, or if you want to talk about the case that you have with them, try to gather some information from them about what their client really is interested in. Demonstrate that you care about them as a person and that you're really listening with an objective of trying to understand what it is they want or how it is they view things. Autonomy, expand yours. Why do you think that's important? Because the more autonomy you have, the better position you are in to be persuasive, to make recommendations, to be heard with regard to various options that you might set forward. But in doing so, you have to always be careful that you don't impinge on the other side's autonomy. You cannot control how the other side negotiates. You can only control how you negotiate. And here's something to keep in mind. Recognize that often it's not the content of a decision, but how it's reached. To enhance someone's autonomy, they need to be part of the decision-making process. Make the other side part of your decision-making process. I have seen people leave mediation without a deal, but if the mediation has gone well, if one side asserted their autonomy and that was respected and they didn't impinge on the other side's autonomy, then the dialogue kept going even after the mediation. So there really wasn't an impasse. The mediation just continued. Something else to consider too with respect to autonomy is that some people need more autonomy than others, either based on their personality type or sometimes culture can impact that. Status. Status is really important because status is power. And the higher the status, the higher the power. The more powerful you are, the better you can do in a negotiation. But keep in mind, you don't really have to compete over status because people can have different status or they can have status in different things. So for instance, your opponent could be an excellent trial lawyer, but you could be a superb negotiator. So you could say to the guy on the other side of the fence, I really respect your expertise as a trial lawyer. We've got great lawyers here at my firm, but I really feel my greatest expertise is in achieving good resolutions for my clients in a negotiated setting. You can also raise your status, and you guys, young lawyers, you'll have the opportunity to do this over time, and I would encourage you to participate in things that would help you raise your status because it's really important. Now I'm going to touch on a couple things you can do strategy-wise in mediation. Openings and joint sessions, very important. Anchoring, bracketing or bookends, and then a technique I call single text negotiation. Here are some things that are really important in the opening. You need to tell your story. You need to focus on the parties, not on the lawyers. You need to speak politely and confidently. You really need to explain your view of the case, but be open to theirs. Be willing to listen to what they have to say about their position, their interests. Be cooperative. Express a willingness to explore settlement. But, oops, sorry, I moved forward accidentally. But also affirm that you have confidence in your legal position and that you're prepared to try this case and win it at any given time. You know, there's a big divergence of opinion out there among mediators nationwide on whether we should even do openings. Here's the most poignant thing I would leave with you about openings and joint sessions. An attacking open does more harm than good, and quite frankly, it's not worth doing. But an effective one is worth its weight in gold. So I'm a big believer in openings. I'm a big believer in joint sessions. I use them all the time. I'll have people together, then I'll put them in private sessions, and then if they have questions for each other or they need to gather more data from each other, I'll bring them back together in a joint session. Anchoring is a very interesting phenomena. It's what we call a powerful cognitive bias. And a cognitive bias is nothing more than a systematic error in judgment. We all make them. We're all subject to them. None of us are immune from them. So what is an anchor? It's really nothing more than an initial reference point. But study after study after study has shown that even if that reference point is arbitrary, it can dictate or at least influence the proposals that follow. So I'm going to encourage you, whether you're on the plaintiff side or the defense, don't be afraid to put the first number on the table. It has huge psychological power. Now, we talked a little bit earlier about what do we do with unreasonable demands. It's kind of the same here with dealing with an unreasonable anchor. You challenge it, question it, seek rationale behind it, but ultimately don't let it cause you to dig in and fail to continue with the negotiations. I know you've probably heard of brackets. In fact, I think we received a question about brackets, but some people are really leery of them, and brackets are just one of those things that you kind of have to learn by doing them. You just learn by experience. But anyway, the reason brackets are popular and the reason they work is because in a negotiation context, people fear the prospect of an unrewarded commitment. And brackets eliminate that fear, because basically what they do is they say, if we do this, then you will do that. And so it takes away or eliminates the fear of the unrewarded commitment by conditioning the commitment, which is just nothing more than a move, on an acceptable reciprocal movement. Again, if we do this, you will do that. So it creates some confidence in the negotiations. So what I want to do is try to go through a brief example here of a bracket, because I know we're getting a little bit short on our time, but this is important. So, so here's what we have. This is where the parties are in the negotiation, very, very far apart, as you can see. So now plaintiff proposes a bracket saying, hey, look, I'll go to A if you go to C, Mr. Defendant, and we will negotiate in that range. Okay, if the defendant accepts that bracket, we know the plaintiff's at A, we know the defendant's at C, and we know that there's kind of a rule of thumb that the plaintiff would make the next move. But that's not what happened in this case. We had the defendant propose a bracket, and so he or she is basically saying, if you go to X, Miss Plaintiff, then we will go to Z and we will negotiate with you in that range. So what do we know by this? We know that the defendant will certainly offer Z, and most likely will never offer X, but most likely will offer something in between X and Z. Then we have another bracket, which is offered by the plaintiff this time, and the plaintiff is saying, okay, I will go to D, Miss Defendant, Mr. Defendant, if you will go to F, and let's negotiate in this range. Then we have the defendant for the last bracket of U and W. I think you get the idea. Basically, the brackets are just each party proposing a range that they would like to negotiate in. So now we have B, Y, E, V. Those letters represent, let's start with B. B represents when the plaintiff makes the first bracket, A to C, B is the midpoint of that bracket and reflects what the plaintiff might accept in the negotiation. Might accept. I'm not going to say for sure. Likewise, in the bracket proposed by the defendant from X to Z, Y, again the midpoint, reflects what the defense might be willing to pay in this negotiation. Same thing with E, and the theory is that as you move through these brackets, they become a little bit more and more narrow, so that the parties are actually brought a little bit closer together with respect to each bracket. So let's sit back and examine, and what do we know from looking at this? We know that our red numbers, or letters, A, Z, D, W, we know that those are movement. Those are real movement, and they're real numbers. We also know that the yellow letters are signals. It's a signal. It's providing information. It's giving a midpoint upon which one party or the other would potentially be willing to settle the case. And then the last, which is the X, the C, the U, and the F, represent a political number or an accommodation. So the idea is that the parties establish a bracket that they're both comfortable with and that they can negotiate in. And then having that bracket established, there's a general rule of thumb that whoever proposed the bracket, if the other side accepts, then the one who proposed it will make the first move within that bracket. Now, what if one of the parties does not accept the bracket proposed by the other party? Well, they could propose a bracket of their own, just like we see in this particular example. So another possibility is you might want to look at the midpoints, and you might want to use those midpoints as establishing new brackets within which the parties can negotiate. The goal here is for the mediator to work with the parties ultimately to move out of these brackets and into some specific numbers. Bear in mind that to become really good at using brackets, you have to have a lot of experience with them. It takes a little bit of time to get used to them, it takes a little bit of time to understand how to respond to them, and it takes a little bit of time to figure out what type of brackets you should be proposing. Another tool that's used by mediators is what we call single text negotiation. This is a fantastic tool and works really well in commercial cases where you've got lots of terms that are going to be involved in reaching a deal. I have mediated a number of big commercial cases and also family disputes, family business disputes, where we started out with a draft agreement, and the whole mediation really was just a circulation of this agreement back and forth. We still had a joint session, we still had private sessions, but basically the draft of the agreement gave us a context within which to work. And so each time someone made a proposal, it would result in a change to the agreement. And there would be, of course, an opportunity for a concession on both sides until ultimately we were able to reach resolution. Probably one of the longest cases I had where we used this technique was an estate case. We started with an agreement, we traded it back and forth. It literally took days. We had 3 or 4 days of mediation, and I tallied up the hours on that, literally 22 hours. But the technique worked, and we eventually did settle the case, and the agreement was probably about 15 pages long. So it's a great tool to use if you've got a lot of terms as part of a negotiated agreement. Now let's talk a little bit about what happens when you get stuck, because you will. You will get stuck in mediation, and part of it is your mindset. If you can just find a way to keep moving, you can break through the impasse. The number one goal of mediation is settlement, but the second goal is to make an informed, intelligent decision. And sometimes that means a decision to walk away from the negotiation. But keep in mind, and I think this is particularly true on the defendant's side of the fence, that it's really not about your number, it's more about their number and your decision. So when I say on the defendant's side of the fence, what I mean is oftentimes a plaintiff has a number in mind, but ultimately it will come down to what the defense's number is and what decision the plaintiff makes about that number. My partner Larry would submit that that applies regardless of which side of the fence you're on, plaintiff or defense. But I think for me, I see it more that it's not really about the plaintiff's number, it's probably more about the defense's number and the plaintiff's decision. So I've only got about 5 more minutes, so I'm going to go through these and these other techniques, and then that'll give us maybe a couple of minutes to handle some of those questions that we had. A mediator's proposal is a great impasse breaking technique. I don't use it a lot because I like to give parties an opportunity to reach their own resolution, but it is effective and it does work. And then of course you can go to the court system and get some direction from the judge. You can try a mock trial. You can use a third-party adjudicator such as an arbitrator. And then we have what we call a downstream process, which I think for your purposes at this point, I'm just going to skip that one. So let's look at the mediator's proposal. So this is where the mediator picks a settlement number. They meet separately with each side. They get a confidential yes or a confidential no. If they get 2 yeses, of course, then that means there's a deal and they disclose that. If they get 2 no's or 1 yes and 1 no, obviously there is no deal, but the party that has refused is not informed of the other party's choice. So it lends a certain amount of protection there, but I don't use this unless I just don't think the case is going to settle any other way, because once you actually have a mediator's proposal, it's kind of hard to get back into negotiations between the parties. I'm not saying it's impossible, but it's a little bit more difficult. And then of course you can have the judge rule on a legal issue if that's blocking a disposition, a negotiated disposition. Mock trials, I think they're great. If you don't have a sense of what a jury would do, either factually or from a damage perspective, mock trials are great for that. Of course, you can only use them on more expensive types of cases, more big litigation. They wouldn't be justified on a little case. You can certainly use, parties can decide to, in a software dispute, rather than going in front of a judge and trying to educate a judge on all the various issues regarding software, they might want to have a binding expert opinion. There's certainly nothing wrong with that. So here's the thing. When I first started my career, I used to never want to admit that there was such a thing as an impasse, but now that I've been at it a while, I realize that clients settle cases. Even the best mediator can't get a resolution if the parties don't want to settle the case. And it's not necessarily a bad thing. Maybe you won't settle that day in mediation, but maybe you'll settle later down the road. Sometimes it's important for there to be legal precedent. I mean, we do have courts for a reason, and sometimes it's necessary for a judge to make a ruling in a particular type of case. But I do think that you need to kind of reflect back and make sure you're making an intelligent decision. Before you try a case, make sure that's really the road that's best for your client and best for that particular type of case. That's really all I have, and I know Santo, we only left about 5 minutes to answer some questions. Here's your CLE information, so take a minute and go ahead and write that down and make sure you've got that for your reporting. I think if we've got 5 minutes, if Santo wants to ask a few questions, I would
Sure.
love to entertain them.
And thank you, first of all, thank you, Michelle. That was fantastic. You really gave us all some great techniques and just things to think about during mediation or even during any normal day of our lives when we, converse with someone else and just have a conversation with the opposing counsel or anyone, really. Something you touched upon earlier, and you promised you would address it, so I want to ask this first. The concept of full settlement authority. I think it's often misunderstood, and this is one of the questions we had. Can you go a little deeper into the full settlement authority issue?
Yeah, sure. We have dealt with this issue a lot through the years in our profession here in Florida, and then of course in other venues as well. But the rule that you folks need to be familiar with is Florida Rules of Civil Procedure, Rule 1.720B and C. And basically, it tells you who has to be present at mediation, and it says that you have to be physically present, and it has to be a party or party representative having full authority to settle without further consultation, and the party's counsel of record, if any, and a representative of an insurance carrier for an insured party who is not such carrier's outside counsel and who has full authority in an amount, here's the key, an amount up to the plaintiff's last demand or policy limits, whichever is less, and then it says without further consultation. The other aspect of full authority to settle is the person, the representative that does have authority to settle, has to be the final decision maker, and they have to be the final decision maker with respect to all the issues presented in the case, and they have to have the legal capacity to execute a binding settlement agreement on behalf of the party. So not to get too far afield, but you could easily envision a situation where, particularly like in an employment lawsuit, where you might need at least two representatives from the employer side of the fence to even meet this requirement. You might need to have an insurance carrier representative if there's an EPLI policy, and then you might also need a corporate representative from the employer who can sign the settlement agreement on behalf of the employer. So you have to really be thinking, who do I need on this agreement and how do I get them to the mediation?
Excellent. And I do want to read out the course ID number for those of us just listening and not seeing the presentation. The CLE credit you need to enter, the code is 15044221N as in November. So that's 15044221 November N. Unfortunately, Michelle, I think we're out of time. If people have follow-up questions, can they contact you?
Sure, feel free. Just give me a little time to respond. That's all. But no, feel free to email me. And also, we have a list of the questions that for those of you who registered and sent in questions when you registered, we have that list, and we'll do our best to respond to those too.
Excellent. Thank you so much, Michelle, for providing this presentation. Like I said earlier, it was fantastic. And thank you, everyone, for attending this webinar. Again, if you ever want to see any of the other webinars that we've done in the past, please go to www.flayld.org. Thank you, and hope everyone has a great day.
Santo, thanks so much, and I also want to extend my thanks to all the participants today from YLD, and I hope you found the seminar to be informative, and feel free to reach out to me. I'd be happy to receive a call from you or an email. Thanks again.